Right, thank you so much for sitting with us here on, or staying with us here. The ones that are sitting with me are Odo and Julia here, of course. Thank you so much for staying with us here on New Dawn. Welcome back as we continue our conversation this particular morning, covering Gachagua versus Senate today. The National Assembly is supposed to present its case in the, to the Senate so that they give the Deputy President an opportunity to defend himself. That is tomorrow, and he will have close to 4 hours to be able to defend himself, put up his case. There'll be a little bit of debate here and there on whatever will have been presented both by the National Assembly and also by the Senate. Witnesses will be presented. There'll be cross-examination. And of course, we will have the process where we are now voting on the 11 grounds that have been leveled against the Deputy President of the Republic of Kenya. And that is the son of Madira, Rigathi Gachagua. Right? There are different cases right now that are playing in the corridors of justice as far as court cases are concerned. And I want to bring you in, Julia, on this one, whether there's hope in the judiciary on this particular matter. We saw there's a bid to try and stop his ouster, whereby they wanted the Senate to not continue with these particular proceedings, but that was thrown out, and of course not willing. The courts to some extent reluctant to interfere with the process in both the National Assembly and the Senate. Does it stand a chance from where you sit in the corridors of justice with this particular impeachment motion?
I think the Senate is an upper house, and they are regarded more objective than subjective, and therefore there could be a chance. There could be a chance, and especially in the courts. Maybe the court is just waiting to see how the Senate plays it out, and then of course now the next level will be there. Will be our courts. I think there is a chance, but also it's looking like it's 50-50. It's looking like it's predetermined, and especially when we see now the campaigns of possible replacement of the Deputy President, and of course Mount Kenya. We said that we don't want that position; it can go elsewhere. But
you don't want that position. But most of these members of, people that are being fronted here are coming from the mountain. You're talking about Governor Anne Waiguru. So should they accept this position?
They're already having positions, so not unless they relinquish. And of course, now that would mean some by-election here and there. And of course, we don't have a properly constituted IBC. I do not even know how we would go about an election if it were to happen tomorrow, because we are not actually ready. And no wonder now somebody officially is bringing the Constitution Amendment 2024 of extension of term limit. And I believe these are people who plan ahead, as Mr. Owido was trying to allude here. Even if you try to plan ahead, one of these fine days, somebody will also plan ahead of you. And therefore, if it is a game of betrayal, then it is playing out clearly, and we are already seeing the betrayal in the city of Kenya, if we may put it like that lightly. So, and I think it's not a good thing. Clearly, it's not a good thing. But if it happens, I keep saying that nobody was born in the position that they are in. Remember, as much as people would say that Gachagua is, or the Deputy President is a creation of the President, remember he was an MP before and also a member of Parliament, and therefore we cannot say he's a creation of anybody. He had already fronted himself there. It's like going to the shamba. There's a saying that we normally say in my culture, that you're in the shamba and then your neighbors are already eating meat, and therefore an eagle comes and picks the meat and drops it to where you are. You're already working, so as much as you're not working for the meat, it has come. So
I want us to go to why the Deputy President might not have gotten the support that he needed, especially, you know, in the National Assembly. 44 is such a small number compared to the number of members of parliament that you have.
I do not want to believe that he didn't have the numbers, but if we go by the hearsay that we are hearing from the member of parliament, that there was money being, money was used. And you know, money is a source of very many evil. And one of the evil is putting our constitution under siege. And if the money exchange, they were given the goodies. Okay. And most of them, they have been caught on camera saying that, let me get what I'm getting for the time being. I think there was a bit of coercion, there was a bit of threatening, there was a bit of, you know, like trying to please the executive, and that is the presidency or the president himself. And I don't think the deputy president, we have seen him in convoys with all these MPs. They have worked together. I don't think he may have loved them wrongly, so badly,
to
such that
impeachment.
Towards impeachment, that he cannot get the numbers.
Okay.
And if I was in that parliament, I'm sure I'll be among the 44.
Among the 44.
Yeah, because I do not believe in this kind of motion. I don't believe in this kind of drama.
All right.
But as we were coming and discussing with Mr. Oide, he told me that the world has more idiots than than good people.
I know where you're going with that.
I know. So, you know, of course. And therefore, there are more idiots in that kind of scenario than the real people.
That is Julius, because you sat down with members of parliament on this particular set. Owidi, let me come to you on what we saw play out in the floor of the House and what we expect to see play out in the Senate. And of course, you know, quasi-judicial, that's what you're calling the Senate. A lot of people have said, to some extent, looks like a little bit of a sober House compared to what we've been able to experience in the National Assembly. But this impeachment seems to be a political process. At the end of the day, if you do not have the numbers, you don't have the numbers. If you cannot get 23, if he can't get 23 to vote in his favor, so that this actually go, gets to enter the Senate, then he doesn't have. You can't pretend, you can't hope for a miracle, because at the end of the day, quasi-judicial, yes, but it's also a political process at the end of the day.
It is more political than it is judicial. That we all know, because even the threshold of evidence required is not like in a judicial case where you need to prove beyond reasonable doubt using hard evidence. I think you people listened to one Otiende Amolo articulate that aspect in the National Assembly. But when we go back to the number of MPs that the DP got in Parliament, Parliament is a random sample of the Kenyan society. So is the Senate. So pro rata most likely would get similar number. But to come and suggest that parliamentarians voted the same way because of some bribery when you did not see and you have no evidence is to get it all wrong. In any case, when you want to bribe 290 people, you can't do it secretly without evidence coming out. So I think it is to get it all wrong there. There's also this propaganda that is coming out that somebody wants to extend the term limit. Okay. There are people in our houses, in our villages, who are contemplating that term limit. But let me tell you, President William Ruto has no interest in that term limit. It is, if anybody is talking about it, that is his story.
Do you know how do you know the president is not
the president doesn't write bills?
Yeah, but
and okay. Even this idea that
how do you know he's not interested in this term limits?
how do you know he's interested? Because if you don't tell me, you are the one bringing the thing for the first time that he's interested. Do you have evidence that he's interested?
This particular interest was, it's not the first time that it has come to the front and made headlines. It was presented during the BBI, not the BBI, the article report, and when they are actually collecting submissions. And it was presented by the Nandi senator, that is Samson Cherargei, but he did not get an opportunity to get to present his views. And now he has drafted a bill, of course, public participation. The public has been invited to, contribute to this on the 25th of this particular month. So, Aaron.
And that very Cherargei is not even on the side of the president. So, if he if he presented that thing, then maybe he was feeling that is what should be done. But it is not a conspiracy that you'd say, because how would Rigathi Gachagua himself prevent that if that were to happen? So you cannot connect those two, the impeachment of Rigathi Gachagua and extension of the presidential term limit. You can't connect them, because if it was going to go through, it would go through whether Gachagua is the DP or not. If that Gachagua can be thrown out by that very assembly, so they can override him with that if the president was interested. Okay. So I think Gachagua has a problem not with the president, he has a problem with the constitution of Kenya. When we go to the Senate, Gachagua will have time again to defend himself. But remember, the accusations that were made against him, even by taking the second bite at his defense, he could still only manage 44. You remember the day before, I think 24 hours earlier, he had called a press conference with no cross-examination. Yeah,
it was 1 hour and 30 minutes.
And defended himself very well to the best of his ability until he said, I have defended myself enough. He got a second bite at the cherry in the National Assembly. He defended himself, but it still did not prevent him getting 44 out of 348 MPs. Okay. So, where we stand, I do not see him winning this case in the Senate. But he's been talking about the courts, and he's only carrying two things to the court: public participation and timeline for the impeachment process. This is what I got to say about those two. Impeachment process. Parliament in the Constitution has the right to make rules on how they do their things, make their own standing orders, decide in their own sitting how they are going to carry out a process. That right cannot even be taken away by the courts. And in that process, he's also relying on what he calls public participation. Public participation, as envisaged in Article 118, which is relying on, does not mean you are going to count the number of people who thinks the other way and incorporate their views into the voting in Parliament. I gave an example of public participation. When you go to a board, the chairman, the corporation secretary, and the CEO must all participate in all board's proceedings, but they do not have voting rights there. The public, again, will have to participate in the National Assembly and Senate, but they do not have voting powers there. In any case, if that were to be the case, we would even want that those who are going to participate in public participation are registered so that we know they are this number, then we count them, then we say this number has decided that Rigathi Gachagua must remain or must go. But again, that would also mean you are usurping the powers of Parliament, or they are gagging Parliament, or they are taking over what Parliament ought to be doing. But this very Parliament was set up by a giant public participation called a referendum that was carried out in this country to bring in the new constitution. So the public had participated. But when you look at the language of Article 118, public participation is simply making Parliament open to the public so that decisions made for them, they are part of it and they know about it. So it is nowhere.
Are you saying that the views of the public are not in any way supposed to be making, to be forming what the Parliament is going to be doing in terms of deciding?
Let me tell you the reasons why public participation was put in the Constitution. Actually, the mischief it was going to cure. Take, for example, there was a case here in the Uhuru regime when they decided to take to Parliament a bill that was then passed that citizens cannot sell unprocessed milk to even their neighbors. That thing was done without public participation. So the public, even up to today, many of them do not even know there is such a law. Those are the mischiefs that were meant to be cured by public participation. So when Parliament is passing bills that are good or are bad to the public, they know about them. It is not that their views are incorporated and things are changed. But how do we, how can we?
And I think that raises a very important question, because in most cases we always have this debate on why were we conducting public participation? Because to some extent, Kenyans believe that the public participation exercise has to make their views incorporated in the decision-making process. And I just want to take that article that you're reading, Article 118.
Read it.
Parliament shall conduct its business in an open manner,
Yes.
and its sittings and those of its committees shall be open to the public and
Correct.
facilitate public participation and involvement in the legislative and other business of Parliament and its committees. Parliament may not exclude the public or any media from any sitting unless it's exceptional circumstances the relevant speaker has determined that there are justifiable reasons for the exclusion. So
just listen to that. Covering Parliament live, the public is even participating from their houses. Opening Parliament and facilitating the public to come in, they are already participating in the proceedings of Parliament. And when you read sub-article 1, A and B, the ones that they're talking, you open Parliament to the public, so that they don't surprise one day when they are told, you know, Parliament passed this bill and you didn't know about it.
So it is just getting, you know, making the Parliament to know that this is exactly what is happening, but not necessarily wanting to incorporate your views.
And why it would not be otherwise is because in the event that you want public participation to be a voting process or an opinion polling process or a referendum process, it means you will have to register the people who are going to do public participation so that you can count them and say this side has gone this way and that side has gone that way. Okay. And where does that leave the parliamentarians who are supposed to vote and decide the fate of somebody? Which of them will have more power? Parliament or the public? Okay. And if it is the public, then we remove Parliament and let the public decide the fate.
All right, Julia, who's supposed to be having more power? Because I remember in our last conversation when we were having here with you, we are taking a look at what was happening during the public participation exercise, especially in different parts of the country with regards to the impeachment of Deputy President Rigathi Gachagua. A lot of people had so many things to say. We carried it live here with comments coming in, from different parts of the country, with different views on this particular public participation exercise. And when the exercise was carried out, of course, there was mayhem and chaos, and people opposed to it. Then we are coming to this particular constitution, which does not indicate in any way that the public participation exercise the views of the people need to be incorporated after the exercise is done. What Owidi here is saying is that we carry the public participation so that you don't feel like you are left out as a people. But then what is your contribution to this very pertinent matter happening in the country?
The ideal situation should be the people sovereignty should actually stand. And what the people say, and that is the citizens, should actually prevail. But look at this. This is a political game, and it is a political, it's a political wave or something that is being handled politically by the powers that be. And therefore, you find that irrespective of the public participation that was carried, that was really expensive, hasty, shambolic, and not satisfactory to how a public participation is supposed to be done. Because we have attended quite a number of public participation. And how they are advertised, and the duration, the timing, and all that. And we have seen the difference in this one. And maybe we need to define is there a special public participation and a public participation? Because this one looks like it's a special public participation.
Okay, Julia.
And that's why I'm saying the issue of public participation on this is fraud. It's not right how it was done. And the views that came from the ground, you know, they keep saying that you listen to the ground. They are not favorable in their ears, and therefore they would like to shun them and disregard them because they did not speak to what they expected. But if they spoke on how they expected, I'm telling you, they would be saying the people said what walisema.
Okay.
Wakenya wameongea.
All right, Wakenya wameongea. And I want to, because there's a bill currently that has been drafted to get to cure the issue of public participation, because public participation has been, would I say, a reason for people to go to the courts and say, you know, this process was carried out, but there was not enough public participation. The public was not informed. And the courts has been able to rule in favor of most of the people that, you know, gave this as a defense as far as this is concerned. Let me come to you on this one. This particular bill that is being drafted at the moment, or has been drafted rather, and, you know, being looked at, and it's currently with the Attorney General, talks about public participation, but now with making sure that Owidi, Amuai, and Julia have an equal voice in this particular process. At the end of the day, any decision that is going to be made, you have to be satisfied. She has to be satisfied. I have to be satisfied. If we bring that particular to the floor, that particular bill, what effects might that have when it comes to the views of different individuals? Because the individuals will not be speaking the same language all the time. People will be speaking different languages. So if you say yes and I say no, and I want my views to be incorporated in that particular conversation, what then happens if you go ahead and, you know, pass it without, despite my objection?
My views about public participation will not change. My view on public participation is that it is meant to have the public informed of what the people they gave the mandate to make decisions on their behalf are doing.
Okay.
They need to be informed. If we were to bring in public participation as a way of finding out those who agree and those who don't agree, we will be having a second referendum at every time we want to use any section of the Constitution to make a clear decision on behalf of the people. Okay. That is the mistake we are going to make. But what shocks me is how a whole country like Kenya, with brilliant lawyers, would misinterpret Article 118 and think it is a referendum or an opinion poll, is what still shocks me. Okay. Because it is misinterpreted. In fact, what we did this time as public participation, I only accept it because it was a way of letting the world and the people know, because this was a political process, that public participation actually took place, and the evidence are these papers the public touched on, because the time frame for dealing with this matter was so short that if that didn't happen, it could run to court, and the court, without looking at Article 118 properly, would declare that no public participation took place. Okay, talking about the courts, I want us to cross over to the corridors of justice at the moment, because on the issue to do with Deputy President Gachagua, of course, a ruling will be made this particular morning. As far as some of the cases that have been you know, put before the court are concerned, as in relation to this particular impeachment. I don't know, yes, do we cross over to Milimani at the moment? Yes, of course, that live picture is coming to you from the courts. Milimani live at the moment as far as Deputy President Rigathi Gachagua's fate is concerned. Those are an argument that was made by his lawyers, and of course we want to see what the courts are going to decide on this particular matter as the process of his impeachment continues in the Senate. All right.
Say good morning.
Good morning, my lord.
Thank you. Petition number 10. Then we'll go to the respondents. My lords, my lady, if you please in the matter. My name is Milimo Benson. I do appear for the first respondent, Lord, I have the privilege of introducing my other colleagues. For the second respondent, Lord, I, the legal hold brief for Mr. Nyamodi and Mr. Gumbo. For the third respondent, my Lord, my learned colleague, Miss Opola, is present before you. All brief for Miss Panji for the third, fourth, and seventh respondents. And my Lord, my learned colleague, Miss Akama, who is present before you. All brief for Mr. Kuyoni for the fifth respondent. And my Lord, I, Nilimo, all brief for Mr. Wanyama for the sixth respondent. And my Lord, for the eighth respondent, my learned colleague, Mr. Kama, who is present before you, has been requested all brief for Mr. Peter, who appears for the eighth respondent. Mr. Peter. For the eighth respondent, my Lord, and that will be for the respondents.
Interested parties?
Thank you, my lord. Presiding my lord and my lady. My name is Nelson Happy. I hear the second conjunct the party, whether it David Mushuki, Manuel Sea, Maura Kabak.
Yes.
I think we are done with the forum, unless somebody's name has not been recorded. I believe that you have already taken the ruling as well as the applications which we had yesterday. This is the ruling in the consolidated applications, in the consolidated petitions. We have considered the submissions of the parties, the facts in those applications, and the arguments and submissions of parties, and we have prepared a ruling which will be perfected in the course of the day. But the summary is as follows. We have given the facts of the proceedings, the relevant submissions and arguments, and for the purposes of today and this morning, because we don't have much time, we'll give you the abridged version of our ruling. Analysis: having carefully considered the applications, the responses, the party submissions, and the various decisions referred to, the court distills the following issues for determination. 1. Whether the applications are res judicata. 2. Depending on one above, whether the applications are merited. As to whether the applications are judicata, the nature and applicability of the doctrine of res judicata is a well-trodden path by the Kenyan courts. In petition numbers 42 and 43 of 2014, which were consolidated, that is Kenya Commercial Bank Limited versus Nuri Coffee Estate Limited and another, the Supreme Court of Kenya, in an elaborate fashion, illustrated the operation of the doctrine of res judicata. We are not going to go into the details about the doctrine of res judicata, but we have considered it there. We have cited several cases in support of the arguments put forth by parties. And returning to the matter at hand, there is no contestation that the first petitioner herein regarding Gachagua filed and prosecuted an application seeking conservative orders in Nairobi High Court Constitutional Petition number E-550 of 2024. On 15th of October 2024, His Lordship, Judge Mwita delivered a ruling on that application. For reasons contained in that ruling, the application was dismissed. The nature of the conservative orders which were sought in the said Nairobi High Court Constitutional Petition number E-550 of 2024 related to various facets of the impeachment proceedings against the first petitioner in this case before the National Assembly and the Senate. Likewise, the applications subject of this ruling also challenged the very pending impeachment proceedings. Learned Senior Counsel, Mr. Paul Mute, urged this court to nevertheless deal with the instant applications for the main reason that this court, as constituted, is an expanded multi-judge bench of the High Court as opposed to the ordinary single bench. The respondents did not, however, find favor with the above position. It was vehemently contended that the instant applications ran afoul the settled doctrine of res judicata. This court has diligently addressed itself to the above arguments. Unfortunately, we did not come across any holding persuasion that a decision of an expanded multi-judge bench of the High Court of Kenya is superior to that of a single judge. This court therefore finds that the challenges raised in the instant applications are similar to those dealt with in Nairobi High Court Constitutional Petition number E-550 of 2024. In applying the tenets of the doctrine of res judicata to this matter, we have no doubt and do hereby find and hold that the applications herein are in four corners with the one dealt with in Nairobi High Court Constitutional Petition number E-550 of 2024. The applications are hence caught up by the doctrine of res judicata. For clarity, the issues raised in the applications before us were fully canvassed by a court of competent and concurrent jurisdiction. Having found as such, and for abundance of caution and the completeness of the record, this court will still consider the second issue, and that is whether conservative orders ought to issue. As a well-settled principle law, a court dealing with an interlocutory application seeking conservative orders is called upon to exercise a restraint and to resist the temptation of making final findings at such stage. We have cited cases or authorities emanating from the Supreme Court on that matter. Therefore, a court exercising jurisdiction in an application for conservative orders must sustain that delicate balance by ensuring that it does not delve into and determine issues which largely fall within the realm of the main dispute. The nature of conservative orders was discussed in the Supreme Court of Kenya Civil Application number 5 of 2014, Gachagua Peter Munya versus Dixon Mwenda Githinji, and I've stated what the court said. It was also discussed in other cases which we have referred to in this. On the principles to be considered by courts in dealing with applications seeking conservative orders, the locus classical case of Gachagua Peter Munya, which I've said, comes to fore. And we have delved into what the court said in that case. We have also cited the case of Board of Management of Uhuru Secondary School versus City County Director of Education. We've also
Of course, I'll be getting back there later on. Three-judge bench of the High Court, that is, it was named by the Chief Justice Martha Koome, deciding whether to stop senators from conducting the impeachment trial of Deputy President Rigathi Gachagua, which is expected to be happening today, in the Senate. Of course, we have also live pictures coming from the Senate, of course, with the Speaker Amason Kingi actually having made his way to the House. Now, yes, with details of this, of course, we'll be updating you as we continue on that particular judgment and what the courts are going to decide, whether to stop this particular impeachment or not, and also what is happening in the House as far as the defense and the prosecution of the case is concerned, with the National Assembly expected to provide evidence for 3 hours today that will see the Deputy President, what we'll call maybe allegations, are proven beyond reasonable doubt to some extent, that will see him out of office. He will also have a chance to defend himself, and that is tomorrow. And of course, as that process continues in the Senate, there's one that is happening in the corridors of justice, one that we have been following closely here, and one that you were able to see just a few minutes ago, where a three-judge bench actually will be making a ruling as far as this process is concerned, whether they're going to stop the process at the Senate or not. Now, the judges include Eric Ogola, who is the presiding judge, Anthony Mrima, and also Frida Mugambi, who are actually expected to be making that particular ruling this morning, as we wait with bated breath for what will happen in the Senate with this particular impeachment.
Indicating the mode of appearance before the Senate, whether in person, by advocate, or in person and by advocate. 3, indicating the names and addresses of the persons to be called as witnesses, if any, and witness statements containing a summary of the evidence to be presented by such witnesses before the Senate. And finally, specifying any other evidence to be relied on. The invitation to appear and the affidavit of service is contained in the documents that the senators will be given for their perusal as they consider the impeachment motion that was filed against the Deputy President. Now, on Monday, 14th of October 2024, the Office of the Clerk of the Senate received a response to the invitation to appear by way of a letter dated 14th of October 2024 from the Clerk of the National Assembly, informing the Speaker of the Senate that the National Assembly would appear before the Senate in person and by advocate. The following members of Parliament had been designated to attend and represent the National Assembly in the proceedings. 1, Honorable Dr. Utiende Amolo, Honorable George Murugana, Honorable Samuel Chepkonga, Honorable John Makali, Honorable Zamzam Mohammed. The team of advocates representing the National Assembly are as follows: Honorable James Orengo, who is the lead counsel, Mr. Paul Nyamodi, Mr. Gumbo Eric, Kipkogei Moses Kipkemoi, Mudomi Thiankolu, Peter Wanyama.
Take your seats, Honorable Senators. I'm informed we do have quorum now, so we'll proceed with our session. Clerk, proceed to call the first order, please.
Order number 1, communication from the chair.
Senator Karungo and Senator Mtata, kindly take your seats. Now, Honorable Senators, I have a communication to make relating to the business of the Senate, as scheduled for consideration during this very solemn sitting. You will recall that at a sitting of the Senate, held on Wednesday, the 9th of October 2024, I appointed today, Wednesday, the 16th of October, and tomorrow, Thursday, the 17th of October 2024, as the days when the Senate will hear the charges and investigate the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya. Now, honorable senators will also recall that at a sitting of the Senate held on Wednesday, the 9th of October 2024, a procedural motion for the alteration of the sitting time of the Senate for Wednesday, 16th and Thursday, 17th of October 2024 was moved and approved to facilitate the impeachment hearing of the Deputy President of the Republic of Kenya. Subsequently, via the Gazette Notice number 13178, I notify the general public that pursuant to Article 145, subsection 3 of the Constitution, and Standing Order 78-1 of the Senate resolved to investigate the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, AGH, Deputy President of the Republic of Kenya, in plenary. Now, honorable senators, regarding the hearing and determination on the proposed removal from office,
Your Lordship, my name is Gachagua for the 7th petition. Mine is just
Mr. Wathuta?
Yes, Judge.
Yes.
It's just more or less a housekeeping request. Firstly, maybe in the course of the day we can get an indication when we can lay our hearts on the ruling for our review. Secondly, after tomorrow's Senate proceedings, and as indicated in the ruling that remedies can be sought thereafter, and noting the challenges that we had last week in lodging documents at the last minute, we are seeking for permission, if need be, to lodge documents manually, just in case the CTS system will not be accessible like it was last week. And that's all, my Lord.
On behalf of the 9 petition, my name is Lempa. I would also be seeking leave to amend the petition to take on what transpires at the Senate.
Mr. Lempa,
Yes.
what are you saying?
I am saying, my Lord, that we will be seeking leave to amend the petition depending on what transpires at the Senate, and will also associate ourselves with the submissions of Mr. T.K. Waduta because of the challenges we experienced last week on the CTS. If necessary, the registry allows us to launch our documents physically.
My lords and my lady, my name is Simon Nguru for the 8th petitioner. I associate myself with the submissions of the past 7 and the 9 petitioners, and also wish to seek leave to amend our petition as the courts have already appreciated the manner in which this matter is mutating, and depending on the outcome between of the Senate tomorrow would then necessitate putting an amendment to fully anticipate that outcome and have it brought before the court. That is all.
We don't want to close out anybody. Is there any person with further comments? Then we'll consult on these applications.
My Lord, for the respondent, I thought you were referring to
okay.
The petition as passed.
All right.
For the response, my Lord, on the applications that have been made by my rally colleagues on leave to amend, my Lord, you shall note that there's been no disclosure on the would-be intended amendments that will be sought, my Lord, to be incorporated if leave were to be granted. My Lord, we want to avoid a situation where we will be faced with a totally new petition disguised, my Lord, as an amendment to the petitions before you. In our humble view, my Lord, there's a very good reason to request that if there's any party, my Lord, who would wish to file an amended pleading, my Lord, that they seek that leave formally by way of an application, so that then, my Lord, the respondents will be given an opportunity to appreciate the nature of the would-be amendments and respond accordingly, my Lord. To seek leave, my Lord, in the nature that have been done, my Lord, an open blanket leave would, my Lord, be totally unfair to the respondent, as we do not know, my Lord, how that leave would be utilized. My Lord, we are therefore vehemently opposed to that application of leave to blanketly amend the petition. My Lord, there are rules that govern amendment of pleadings, and before you grant that leave, my Lord, you must be satisfied that that threshold has been met. None has been demonstrated, my Lord, by the blanket request that have been made by our land colleagues. My Lord, on the other request that we mentioned this month on Friday, my Lord, I will refer you to the ruling that you delivered this morning, where you've been expressed, my Lord, that this court would provide a remedy at whatever time it moved appropriately. You've also, my Lord, stated that it will not be right for a party to anticipate or engage this court in speculation. To therefore, my Lord, seek a mention on Friday, my Lord, based on the same reasons of speculation and anticipation, my Lord, would be contemptuous, my Lord, of the ruling that you have delivered. My Lord, we had indicated before you yesterday that we have about 23 matters related to the consolidated petitions before you. My Lord, we've hardly had time to, my Lord, engage in those matters. The petitioners before you, my Lord, have had their share of the judicial time.
Mr. Mlimo, if we were to know what we are going to say, we are going to limit the time, because the applicants have not used the amount of time you have used in response.
Thank you. My Lord, therefore, I would request that you do not give them, my Lord, that request for Friday. That, my Lord, you allow this matter then to take its normal cue
And that, my Lord, we will be available to come back before you any other date, my Lord, next week, for a mention. I should note, my Lord, all our other colleagues are before the Senate. They are not here, my Lord. We do not have their diaries. We request, my Lord, that you decline that request to appear before you on Friday. I thank you.
Thank you.
Lord, and the leadership, it will be just 1 minute to respond to those issues. As regards the issue of amendment to the petition, Lord, at the time a petitioner is approaching the court for a remedy, you don't disclose essentially what the nature of the petition is. A party is free to file a case before the court and raise issues where the respondents will then have a chance to respond. So that in case an amended petition, your Lordship, is filed, the respondents will not be prejudiced in any way because they will have an opportunity to respond to the amended petition. So that even if there's a change of the prayers or anything in the petition, then they will have an opportunity to respond to anything that could be introduced in the amended petition, so that there is no harm in allowing that particular prayer. And we have had an experience in this, my Lord, in a matter that was filed in Kiambu. When parties sought to amend the petition, Mr. Milimo's side opposed the amended petition on the basis that leave had not been granted. So to avoid all that, and noting that this is a matter that has very strict time constraints, we would think that it would be prudent that these courts allow at this time that you can file an amended petition. On the second issue, the mention of Friday, so the outcome is two. The deputy president can either be impeached or the charges before the Senate might be dropped so that they are not confirmed. So that it will also be important for the court's program to know what is the outcome of this particular matter that is of great public interest. The mention on Friday will therefore help in updating this honorable court on the outcome of that particular process before the Senate, so that we either seek directions for hearing of the petition or we update the court, as we are hoping that the charges will be dropped, that these petitions have then been taken by them, so that they don't continue holding the shares of the court. So that it is important that we don't spend a lot of time in getting directions for these petitions that are pending before the court. That is why the mention is urgently needed, so that we can address that issue conclusively. Thank you.
On behalf of yes, my Lord, my ladies, yesterday when we were online, I heard Mr. Milimo saying that parties are bound by their pleadings. And therefore, it cannot be heard this morning to bar the same parties from amending their petition. My Lord, my lady, this court has powers and jurisdiction to guard itself from abuse by any party seeking amendment of its pleadings. And therefore, the submissions by Mr. Milimo are speculative that parties indeed intend to abuse the process by making or introducing matters that would render the petitions totally new. My Lord, my lady, I've had Mr. Milimo submit that advocates who are not present, they have no advantage of taking the directions that will be given. Every party that has been here has actually given an indication that they are holding grief for certain people. Therefore, no party will be prejudiced by any direction that is given by this court. In conclusion, Mr. Milimo's opposition to the amendment of our petition is just filibustering of this matter.
What did you say? That word. It's just. What did you say?
It's filibustering.
Filibustering. What's the spelling? Filibustering.
Yes.
To?
Filibustering the matter.
What does that word mean? What is the meaning of that?
To stall the process.
To stall the process.
Yes.
That's an easier way of saying
yes.
it. Yes.
Delaying something without necessarily breaking the law is what filibustering is. My assistant is assisting the definition of filibustering, but I had looked at it before deciding to use it. So that it's an opposition for opposition's sake. Nobody intends to abuse the process of this law by amending. We'll add a paragraph or thereabout, and he knows what is like. Parties have submitted, depending on what will happen in the Senate, they be given leave to amend their petitions or their respective meetings. That does not amount to an abuse of court process. That's all.
Thank you. Do you have any parties online who want to comment on this matter?
Malad, if I may just make one remark, and this one is for the benefit of Mr. Milimo. Last week on 11th of October, in Kerugoya, in petition number E014 of 2024, which is related to this subject, this issue arose before your brother, Justice Mwongo. And in a recent ruling, which you'll be getting a copy of today, Mr. Milimo vehemently opposed a similar application for amendment, and the judge made a ruling where he allowed these kinds of amendments. And what the judge said is that the mutating nature of this process necessitates constant updating and amendments. So this is not one of those cases where facts exist and they don't change. They change every day. So that by the end of today, by the end of tomorrow, the facts will be totally different. So let us leave that room open, at least up to the conclusion of the Senate proceedings. Thank you.
My Lord, for the record, my red colleague will confirm, I was not in Kerugoya. I don't know whether I'm prominently telling. We must withdraw. I was not in Kerugoya.
Sorry, my Lord, Mr. Nyamonde, his senior is the one who was leading the delegation.
Thank you.
My Lord, my lady, on the part, my name is Opola, for the 3rd, 4th, and 7th respondent. On our part, we thank you for your ruling this morning, and we thank you for allowing the 4th respondent to proceed with the constitutional process before it. On the applications made by counsel to the petitioners, we shall abide by the directions of this.
Thank you. Do you have any parties, counsel online, who wish to comment on the application for leave to amend petitions? If there's none, I think you cannot amend petitions except by leave of court, and therefore the issue which we have raised, we need to consult on it and give an appropriate ruling. We'll therefore adjourn for 20 minutes.
All right, those were live proceedings from Milimani Law Courts, where the three-judge bench was deciding the fate of Deputy President Rigathi Gachagua as far as his impeachment at the Senate is concerned. They had wanted conservative orders to stop the process at the Senate, but the court has declined to stop this impeachment trial at the Senate. And of course, the process continues at the upper house, where the National Assembly today, of course, will be presenting their case, and the Deputy President will be given an opportunity to be able to defend himself. That is tomorrow. Let me come to you. To some extent, did you anticipate that this was going to happen, what we've been able to experience in the House? Let me start with you, Owidi.
That is what I had told you much earlier. That, the Parliament, National Assembly, is a random sample of our society, Kenya.
Okay.
The Senate is also a smaller random sample. So you expect what happened in the National Assembly to easily happen in the Senate. But in the courts also, if you listened to the judge in the beginning, most of those cases we're talking about, some of them had been ruled on much earlier, because you remember this is actually the 27th case brought in by the DP to save himself. So most of the facts he's relying on have been dealt with. Most of the sections of law is relying on have been dealt with in the past. So I didn't expect anything different. And I said before, we cannot set some of this bad precedent that will haunt us in future.
Okay.
If you begin to stop a legislative process using the courts, it may bring in also a tug of war between the two arms of government.
All right, sir.
And also future precedents that may not be good for the country.
Okay, I do want to take a break here on the program as we continue the coverage of the Gachagua impeachment at the Senate. And of course, when we come back, we'll be taking a look at what exactly happened, what exactly should we be looking at, and what to expect. Of course, continue engaging us on our socials at K24 across all social media platforms. At Amoy Brand, that is on X. We'll be sampling your feedback as we continue with the program this particular morning. Of course, on your take on this impeachment motion against the second in command in the country. We take a break. We will be back in a few.
Karibuni. Hii ndio base ya the best local entertainment.
Sitakubali ukalie kiti cha umiliki katika kampuni ya mume.